Well, good morning. Good morning to everybody. It seems like every weekend we've had colder weather on Sunday than any day, but today is not so cold. It's nice and pleasant outside. I was thinking about skipping church and going fishing, but I decided since I'm supposed to preach today, I should stay here, but be here. But anyway, we got a bunch of people gone, about 15 cruisers out in the middle of the ocean on the way to Hawaii, I think. And Jerry and Mary really wanted to go, but Jerry gets sick on the boat, so he decided not to go again. So, Brenda, I thought you and Andy were going. You don't go cruise? Oh, Andy gets sick too. Okay. Yeah, that's why I didn't go. I didn't want to get sick because of finances. Okay. And then we've got all of our teens are in Savannah, Tennessee for the Evangelism University. So we got a lot of people gone today, but what we lack in quantity, we make up in quality this morning. So we're glad that you're here. David Brogdon is here again, and he's going to be talking about end-of-life decisions and medical directives and power of attorneys. And then at the end, he's going to have some time, I hope, to answer some specific questions that you might have. So be sure to be thinking about those as he shares with us this morning. We appreciate him coming and sharing with us on 2 Sundays. Brian Reagan could not be here today, so David consented to pinch hit for him, and I'm sure he'll hit a home run. So we're just glad. We are taping these, so if you have a question, I've asked David if either he or I will repeat the question so we can pick it up on the monitor in the back, so it'll go through our system. And the one from Tommy Marvin is already on the website. I don't think the one that David did last Sunday is on the website yet, but if you missed the presentation by Tommy Marvin 3 Sundays ago, it is on our website. Just go to resources and you can actually play the tape right there on your computer. So it's very helpful there. So anybody else that you talk about that has might have a question about end-of-life decisions and aging gracefully, just tell them to get on the website and find out some information. We're also putting some additional information on the website about aging. Some of the materials that I have shared with you are already on the website, so go to our BurnsChurchOfChrist.org website. Is it org or com? It's org. Anyway, look on the bulletin. .org. Okay. And find out information. And then next week we're going to be continuing our study on aging gracefully, and we'll be looking at things like caregivers' Bill of Rights. And then I want to talk a little bit about, sometime either then or the first Sunday in February, talk a little bit about things like David's going to talk about today about end-of-life issues and medical directives, but things like when can you pull the plug. So my wife says she wants to know that one. So anyway, we're glad you're here, and I hope that the presentation will be really appropriate and practical for you. And as we begin, let's begin with prayer. Father, we're thankful again for the life that you've given us and for the health that allows us to be with us, be with each other today, and thank you for allowing us that good health. We pray your blessings now upon us as we participate in the presentation that David has prepared, and we pray your blessings upon him, and thank you for allowing him to be among us today. Bless each one as we try to live for you. We pray in the name of Christ. Amen. David.
Well, good morning. Last week we tried to cover a lot of information, and I think we did. And as I said last week, we gave a caveat that what we're doing here is we can't possibly cover everything, and there are fact-dependent situations that everybody has. So as an overview of what we're doing, it can only be considered marginal legal advice, primarily because your situation may differ from another. I can give you example after example of situations that come before us every day in our office. It may not be exactly like yours, and it could be some feature or facet of your situation that may make the whole scenario change. It's constantly that way. Last week we talked about wills, and I wanted to cover a few things about wills this week because of some questions that were asked of me as we were leaving the building last week. And if you have your outline, there was a name of Virginia Patterson Hensley. Does anybody who know what she's better known for? What a better name for Virginia Patterson Hensley? Nobody. That was Patsy Cline. Okay. Everybody knows Patsy Cline. Even the younger people in the class know Patsy Cline. In Tennessee, Patsy Cline's will became an issue that is still the law today. It's very interesting. As you know, she had died in a plane accident, Camden, Tennessee. She had written a few weeks earlier her will on a Delta Airlines stationery. Now, as she wrote it, she basically wrote her name out as Virginia Patterson Hensley, Patsy Cline, in her handwriting on this so-and-so date of whatever year, I think 1963, 67, whatever year it was. But at the very bottom, they didn't have a signature at the bottom. Well, there's no witnesses. You know, you've always heard a will needs to be witnessed or notarized. It was just completely in her handwriting. And the argument against her will being valid was that it was not signed or dated. Well, the interesting thing, the Supreme Court of Tennessee said no, it was signed and dated. Her signature was in her hand at the very beginning of the will. Her signature was in the body of the will, and she said what date it was. She declared it was her will, and that was a handwritten will that was valid in Tennessee, and that is still the standard today in Tennessee. Handwritten wills are one of the three types of wills that are permitted in Tennessee. If you've got a paper sack, I hardly see those anymore, but or a napkin or whatever you call it, you write it out in your own handwriting and you write out a will, that will is valid. It doesn't have to be notarized. Matter of fact, it's notary on a handwritten will is of no use whatsoever. Witnesses on a handwritten will is of no use whatsoever. It just has to be in your handwriting. It has to be dated, and it has to have your signature on it. Now, if it's in the body of the will, that's considered a signature. What has to happen to probate that will is to have two people that are not listed in the will to take from the will to identify that that is that person's handwriting, and sign an affidavit, and the affidavit's presented to the court, and that makes that a valid will in Tennessee. There also another will, and it's basically a verbal will, because people ask me all the time, can I just video what I want to be done in the technology age? Why not do that? Videos themselves are not necessarily a will, but a will can be made by a verbal declaration in fear of imminent death. In law school, they tell you the primary example would be a military soldier out on the battlefield, and he recites the terms of what he wants to do, and someone has to write that down within 30 days, and that can be a will that satisfies a requirement. You virtually never see that. I have, as long as I've been practicing law, I have not seen one, but that's a proper will. The last one is the lawyer's type of will. That's the typewritten will, and that's the one that causes so many problems. You can get on the internet. As I told you, not everything on the internet is accurate. And there's forms, and there's fill-in-the-blank forms. And I ran through family member after family member that would have a fill-in-the-blank will, and I said, well, who filled in those blanks? Well, so-and-so, my daughter did, or my niece did, and so forth, and you signed it, and you got it notarized. Yes, that was the story. Well, the bottom line is you had to go back to the Patsy Cline will. Supreme Court says that those wills that you fill in the blank are basically not any good unless you consider them a handwritten will. Now, what do you remember about a handwritten will? It's got to be in the handwriting of the testator, the person giving the will. So if her daughter filled in the blanks, then that will is no good. It does not fit the requirements of a handwritten will. And if you considered a lawyer type or a typewritten will with fill in the blanks, the requirement at that point is you have to have two witnesses watch the person sign and declare that that's their will. Now, a misconception is that the person that's a testator's signature is notarized. That is not the case. What is notarized is those witnesses. It's an affidavit attached to the will, an attestation clause, as you may call it, and their signatures are notarized that yes, they were present. So there's some features about a will that's a typewritten will that if you don't follow the proper requirements, it may not be valid at all. You get a question, James?
So if we came to your office to get a will made, you would make out the will, we would sign it in the presence of two witnesses, and that would then validate the will.
That would make it a self-proving will.
So you'd have somebody in your office that would
we always have somebody in the office because, again, it can't be somebody that's going to take from the will. So if you list your kids on the will and your kids show up and they say, we're going to be witnesses, that basically invalidates the will. And invalidation, a judge could declare it's invalid on its face, or if you have anyone contesting it. We got a call Monday morning last week. Individual had passed away, and she had willed everything to one daughter. She had 5 other children, but everything to one daughter. Well, the son representing the kids said something's wrong. Mother must have been incompetent. She wouldn't have done that at that time. We know she was going through some problems. And my answer to him, I said, well, to be able to prove that she was incompetent at the time she wrote the will, we need to get some medical records and so forth to see if that would help. And that may not help. And I'll tell you why. Judge Jackson, the probate court judge, was in our office the other day explaining to us about a gentleman that came into his court. They were trying to file a conservatorship on the man. The family was there. And as he presented himself to the court, he knew everything going on. He knew what the today was. He knew what was going on in politics and this, that, and the other. And all of a sudden, one of the family members said something to him, and he went back to 1940-something. He was talking to the judge as if the judge was President Eisenhower. Judge Jackson said he's never seen anything like that. Now, he and I talked about the situation. I said, well, Judge, when the man was in his state where you thought he was all right, if he had presented himself to a lawyer's office in that state and the lawyer prepared a power of attorney, a will, whatever, he said it would have to be valid. He said the rule for lawyers in preparing those documents is the person has to be in a competent state in the opinion of the lawyer at the time they enter that agreement or write that will or write that power of attorney. There's no requirement that we have to have letters from doctors saying the person is absolutely competent, so forth. I don't know if something will ever change. I know I've had situations where I didn't feel very comfortable with the person being competent when they came, and I've refused to prepare the documents. And the individual says, but I promise you I'm okay. I know I have these state, and they bring me documentation from their doctor. It makes you a little uncomfortable, but it's really the lawyer's decision to go ahead with the will or not. So you're putting a lot of pressure on a lawyer to make that decision, and that's why lawyers are sometimes deposed after wills that are in probate or in contest there. Last week we talked some about power of attorneys, and we talked about the living will, which is also considered a power of attorney for health care. Dr. Hinkle wanted me to touch upon advanced directives, medical directives, and so forth. They're all kind of the same. They use different headings and wordings. When we leave here one day next week, I'm going to forward some links to the sites with the Department of Human Services and the Department of Health. And something that probably, if you just make a phone call to most lawyers, you're not going to hear them say, there are certain times you don't really need a lawyer. And if it's an advanced directive, if you go to the Tennessee Department of Health website, they have several forms that you can fill out for advanced directives, healthcare power of attorneys. Now, I'm going to tell you, you can have one printed up in the lawyer's office, and it'll be several pages, significant pages, like as we left examples up here. But the state of Tennessee is on the cutting edge of what is accepted throughout the state. Hospitals accept the forms that the state of Tennessee put out as forms. And most lawyers' offices do. If you brought me a form that you had printed off from the State of Tennessee website and you filled in your advanced directives for health care, I wouldn't change anything, generally. There's several fill-in-the-blanks, including, as what Tommy Marvin had spoken. I looked at some of the forms last week at the office, and there is a section there about burial and those type of decisions that need to be done, because the person who has the power of attorney for health care, by statute in Tennessee, has the authority to make those decisions for any one of you for burial, cremation, any of those type things, all the way up into death. It's basically considered a medical directive. Unlike the power of attorney for financial, the minute the person passes away, that power of attorney is completely over and done with. The healthcare power of attorney, or the advanced directive as the state calls it, allows that person to continue to make those decisions, as cold as I say it, till you're in the ground or you're cremated, if that's what you desire, and so forth. So there's a form there. That's the best direction I can tell you. There's also, the state form also has blanks that ask whether or not you want to be on life support system or you want CPR done and those type of things. I noticed I had surgery before Christmas, and as I told you, lawyers don't have wills as the general rule, procrastinators as we are. They handed me a living will or an advanced directive. They wanted me to fill it out. It looked very, very similar to what the state of Tennessee form has. And it wanted to know who's going to make those decisions. I said, well, Sonia's going to make those decisions. I don't even want to mark the ones about CPR or anything like that. Just let her do it. She's more straightforward. Her head's on straight better than mine. I would be very emotional about it. So whatever she decided, they laughed at me a little, but they have the forms there. The state of Tennessee recommends take that power of attorney of health care and make sure your doctor has a copy of it. If you were here last week and I told you about your actual will that you make, your last will and testament, I recommend you never make a copy of it. The power of attorney for health care, state of Tennessee's website tells you to make a copy of it. Make sure your doctor has a copy, and anyone in the family that needs to have one has a copy of it. I think that's an exception to the rule of the last will and testament, and I think that's a good idea. Again, if you want to change your power of attorney, you rip it up, but there's still copies out there. You better do another one. Whereas a will, the revocation of a will, you can rip it up, burn it, write revoked across it, or draw a new will. The power of attorney, you need, if you do another one, you need to make sure all the people that had the copy gets a new copy and make sure they've got an updated copy. The other thing when I was going to mention, when I had surgery, one of the scary things there's 19 items on the list. Anybody that's had surgery in recent months or years, there's 19 items that the anesthesiologist makes you look at and read them and make sure you understand that any one of these things happen. And the last one, number 19, is death, and that really scares you. Here I am, I hadn't turned 50 yet, and I'm reading all the things that can happen when you have anesthesia given to you, and everything else is bad as well, but the worst one was death. I just, at that point, I decided I didn't want to have surgery, but she talked me into going ahead and doing it. So.
I assume it's normal if you go into a hospital for surgery that they've asked that medical directives to fill out that. Is that? They are. I know that's been my experience. I understand,
Sonia works in the hospital field as well. She knows that they do it. They also have liaisons in the hospital that try to go, if you're in a hospital room before surgery and whatever, they go and talk with you and try to make sure that you have all those things ready.
But if you have a heart attack and you're taken to the emergency room, you don't have time for
You don't have
medical
time for that.
directives. So if Sonia's not there, Emily will take over for her. She'll say, just pull the plug, okay?
But on the same token, David,
Right.
I thank you for your lesson about that. On the same token, if you don't fill out the advance directive, it's been that way for a long time.
Right.
You know, with it, and you don't, I mean, because sometimes hospitals make you feel forced to sign this thing that if you don't sign it, you're doing your family a terrible disservice.
Right.
And that's not necessarily the case either.
That's right. Just, you know, in your situation as mine, your spouse has a lot of say, and the hospital is going to generally listen to what your spouse, if it's your child, they're going to listen to the parents. As many of you may have had with older, with grandparents that I had, they wanted all the family members to come together and everybody agree, so there wasn't any problem. But it doesn't mean things will not be done and be taken care of. It's just they could be problematic. And burial situations, if there's been no directives regarding that, as Tom Marvin may have alluded to, that could be a little bit of difficulty. Dr. Hick and I were talking before we started the lesson about individual who was ordered or told not to show up at the funeral home when their family member had passed away, and they made arrangements for some type of private viewing. We've had situations where people have actually gone and got order of protections to keep family members from showing up at the funeral home. So, you know, it's good. It would be very good to go ahead and get those advance directives in place so problems like that don't happen. And where you've got a blended family, where you've got divorce, remarriage, and all involved, sometimes the emotions can kind of get sideways in situations like that, and you've got to plan on those type of things. And if you go ahead and get those advance directives in it now when you got a chance, and it's so easy. You go right on the website, the Department of Health. If you just Google Department of Health, there's a link on it, and you go to the advance directives. There's a particular link for advance directives or living wills, and it's a fill-in-the-blank form. You can print it out. And I will warn you, there is a section on those that says either have it notarized or witnessed by two witnesses. And unlike the will that I talked about that we would do in our office, the state of Tennessee says it's either or. You don't need to have it notarized and witnessed. You have it notarized or witnessed. So when you go to the Department of Health, just do a Google search, go down the line for that. Just remember that, and it tells you everything is outlined exactly how you have to do it. Now, if you come to a lawyer's office generally to get a will done, unless a person just says all I want is a will, generally attorneys in our state will encourage you to go ahead and get your power of attorney and living will done. It's encouragement to do it. We charge nothing to do the power of attorneys, anything more for that than we do the will, because we think it's such an important matter. If we can get you in there and get you to do the will, we're going to make sure you have that available, and don't want anybody to think that's cost. I want to save money, I don't want to do that. We just say, look, it's a whole package. We just do it all together. A lot of lawyers do that as well. I think it's a good practice because, again, I think a power of attorney is more important than a will 9 times out of 10.
You make your own power of attorney or use the form given to you by the state. You have to have it
either notarized or witnessed. The question was if you use the form from the state, you have it notarized. It gives you the instructions on there, and it says there's a box A and there's a box B at the bottom of that form. And it says either A or B needs to be completed to make the advance directive valid. And one of them is to have 2 witnesses. The other one is to have your signature notarized. So it's either or. I don't think it would be fatal if you had all of it done, had notary as well. But the instructions say just have it's either or.
Is it possible? I mean, to not even have a judge or lawyer or anything, just write out the will. I mean, if you're not filthy rich, why can't you just write a will and your
Okay. Question is can you not just write a will and not have to have a judge, a lawyer, and so forth involved? You can absolutely write a will as long as the criteria is met, write a will that is valid. A will itself is not valid after your death until it has been probated. Okay? A court has to declare that that will is a valid will and place it in probate. Okay? Now, in reality, if you don't have a lot of things, you just got some furniture in an apartment, and you pass away, and your kids know, you know, there's stickers on this. This goes to this one, that one, whatever, and the kids are not going to fight amongst each other. Are you going to have problems? Reality, probably not. But if you're going to have a will, and you want the will to be followed as you have written it, the only way to make sure that it is to have that will probated. Now, there are ways of avoiding probate altogether. Now, I hit on last week some trust. There, I think I found 19 or plus different types of trust, and every one of those are completely fact dependent on what you want to do and what you want in the future. There's taxable trust. That's trust that you'll be taxed on. There's some that you won't. There's some that you have some rights in to be able to change it, some that you don't. So I don't want to touch a lot on trust because it's such a varied subject. But there are some trusts that you can place monies in to avoid probate. There's also gifting. And I had checked, let's see here. Yeah, the gift tax now is gone. So years ago, we would tell people that come in our office, if you were going to gift a house, a $100,000 house, to your son and your daughter and their spouses, that you could give a certain amount to each one of them every year if you wanted to transfer it over until you used up the $100,000 of the value of your house. Because you couldn't just deed over the $100,000 house to one or two or four children. You could with four, but if two children, you couldn't deed it over because the amount that would be transferred was greater than at the free gifting level in the state of Tennessee, and it fluctuated. We had at one time it was 11,000. I think you got 11,500, 12, and I think the last time we had it was 13,000. There where Dr. Hinkle could give away $13,000 to each one of his children and each one of the spouses of the children without him having to pay a gift tax. If he decided he was going to give $20,000 to each one of them, then the difference, $7,000, he would have to pay gift tax on that $7,000 within 9 months after he gave it. That was a fine how you do if you came into significant money and wanted to give it away. Well, right now, the gift tax in Tennessee has been abolished. Now, with legislature, I heard on the news this week they were looking at a down revenue year. So they're going to be looking for new ways to come up with taxes. Will they go back and put the gift tax back? We got a Republican governor that says he doesn't think that he wants to do that. I don't know what's going to happen in the future. We may get other type of taxes as well, but that may come back into place. But as of right now, it appears to be unlimited, both federal and state, to be able to give you things away. And I do caution you, if you decide that you have significant assets and you want to give them away, always worry about grandkids. Before you give anything away to grandkids, always go talk to your tax professional. And the reason being, giving directly to your children is one thing, but there are tax ramifications for generation skipping. Okay? You may or may not have heard that word, but generation skipping. The federal government doesn't like you to give it to great grandkids or great grandkids and so forth, but leaving a legacy that doesn't have to be taxed. So I'm not a tax expert. I just know that those are some of the issues we always tell people that want to give things away. You need to go talk to an accountant before we do anything else, because I don't want to give you bad bad accounting tax advice. But there always are issues related to generation skipping. and it even is that way in a will. And that kind of brings me to another subject about, I'm going to go back in wills again. I've seen some people write out little notes and say, here's what I want to do. I want to give this farm to my son for his life, and after that to his children, and then to their children, and they want to carry it on out. It's not valid in Tennessee. If the person that you're referencing to have something is not living at the time you do the will, it violates what they call the rule of perpetuities. The person has to be living, and you can have the person living plus 21 years, I think is the last rule in Tennessee. But that's something you need, if you want to keep something as a legacy for a long period of time, that's when you need to talk to a lawyer about it, because there are certain rules that you have to follow. You can't give something to your great-grandchild that hasn't been born yet in a will, because it's basically an invalid provision. So.
I have another question. This is more of in answer to what Judy said a minute ago. Once I get it on, I'll speak.
Well, let me take Andy. Okay.
You repeat.
Okay.
She doesn't want a will. She doesn't want anything. Okay. She's got some other issues, like her name is on a car title. She's on Social Security. She gets disability. She gets this, that, the other. Who has the power to call the Social Security and say she's dead? Who has the power to sell her car that her signature is on? Those are issues that we might.
Well, that is a good question. Now, there's some practical things about a car that, since we're being taped, I won't discuss. Afterwards, we talk about it. But there are some practical ways to transfer automobiles without going to probate court. Our court does not like us to mention that, but there are ways to transfer that. Usually affidavits from the only heirs and so forth, and that's as far as I'll go with that. But the car could be transferred. As to Social Security, if you're on Social Security, generally you have, when you applied, you have someone who is listed as a contact person. Is that anybody on Social Security that's applied and you know the contact person? Usually, what I have seen come in our office, there's someone to contact should you not be competent or able to contact. That's what we generally see. And as you list a family member to be contacted in the event that you're not, especially in the event that this person's put in a nursing home. Who is to be contacted? Sometimes it's a nursing home representative, sometimes it's a family member. So the Social Security, I think anybody could contact them to let them know, and I think the Social Security at that point in time would contact or verify that usually will require a death certificate. But the Social Security money, that's something that does come up quite often. Social Security doesn't know a person has passed away for several months. Well, the Social Security checks keep coming in after the person's passed away. Well, don't think that was just free money that's in mama's or daddy's account, because you're going to have to pay that back to Social Security. So at some point it will come back to bite you, and that's why the death certificate, so as soon as you can have that and let Social Security know, so they can stop those payments, because so much of it is direct deposited into people's account.
And if there's debt,
Okay.
if the person owns on a house,
Mm-hmm. Yeah, there's a lot of issues relating with debt, as Dr. Hinkle asked. Who can probate an estate? Your family can, or creditors can. No, people don't think about that. Credit card company that's owed a lot of money can probate your estate for the sole purpose of getting the money out of your estate. People don't think about that. Lawyers in car accidents, you're involved in a car accident and you pass away, your family hasn't filed probate. There's no probate on file at the courthouse. The injured people that you caused injury to as a result of the accident and your death can then, through their lawyer, file probate to set it up so they can sue your estate for the damages that they caused. So, yeah, creditors can do that. If you, as a family member, file a probate, you are obligated to pay all the taxes. Right now there are no taxes for the most part. It won't be any after 2015. And that has to be over $5 million at that point in time. But any taxes that are due, any TennCare, and any creditors have to be paid out of the estate before the estate can be distributed to anyone. And TennCare, if for some reason you've had TennCare health benefits or nursing home visits or whatever, they have a lien on any of that regardless of the length of time. Creditors, as I said, can file against your estate. Creditors only have 1 year from the time of your death to make that claim. Now, a lot of people will come to our office and not want to file a probate on the estate of their family member until it's been a day after 1 year from the death. There is some logic behind that, because if they do, any of the credit card companies, they're barred from coming after the estate because more than 1 year has passed. So if the credit card companies have not filed prior to that, they're forever barred. There's an exception, and that exception is TennCare. The Supreme Court declared that too many lawyers were advising people just wait for that 1 year so TennCare can't come after you. And the state said this violates everything that TennCare stands for, and it violates federal law. Federal government says TennCare must subrogate or collect after death. So there's unlimited time for TennCare to come after you. So that's part of the reason when we file estate probates, we send a clearance into TennCare, and it's asking, is there anything that's owed to TennCare? If there is, let us know immediately. And generally they send us a release that says no, nothing's owed, or X number of dollars is owed. And we've had situations where a person owes $100,000 in TennCare and left a house that's worth $40,000. Now, what do you do about that? You can sell the house and it won't cover the $100,000. Well, TennCare is, they're reasonable, I guess. They will say that if you can sell the house at the fair market value, they'll write off the complete lien for the fair market value. You don't have to come up with the $100,000. And that happens fairly frequently. We see that happen from probably 3 or 4 times a year with TennCare involvement. Andy, did we cover anything?
Well, that's pretty well what I was going to ask that question. The creditors will get theirs first.
They're going to get to, and if you're handling the probate, if I'm the attorney handling the probate, and we know that there's creditors out there, we are required to notify them of the death directly. Now, the paper, they put it out in the paper for 2 to 4 weeks as notice. Well, somebody in Memphis may not see the paper in Dixon to know that there's creditors. So if we know by going through the paperwork of the deceased that there was something owed to this creditor, that we have an obligation to notify them that the person has passed. We have no requirement to make them take money. It's their duty then to file a claim against the estate, but we have to let them know about it.
But the debt does not pass on. In other words, if you're a widow and you die and you have debt and the estate can't cover it all, you don't have to worry that you got to pay. It's history. It's wrong.
Not unless you sign as a guarantor, such as the hospitals, when you or the nursing home. How many times we see that where your loved one goes in the nursing home and they sign, but that's not good enough. They want the younger person working that's got a job to sign their name on it too, so they can be a guarantee to make sure that the debt gets paid. So other than a guarantee that you've signed, it's the same thing with husbands and wives. And I know we're short on time on credit cards. If a credit card is only in your name, okay. Sonia has a credit card only in her name. She runs it up to $50,000 and she passes away. I have no obligation to that unless I'm on that credit card with her. That's hers solely. even if they came after her while both of us were living and wanted to sue, they can't garnish my income for a debt that she's incurred. So it's kind of on the same line of what you talk about, Jeff. They most definitely do. Anything else?
What if you make payments on his dead wife's credit card for a year and a day? Just they don't come after you, so you can probate the estate and come back to them.
That's probably not a good thing to do. Yeah, I think you voluntarily agreed to pay once you start making payments, and at least that's what they're going to argue. And the statute of limitations, once payments are made, statute of limitations doesn't start running until your last payment. So if you made a payment today, it'll be another year that they still have a claim.
We got it covered, don't we?
I think they do. Any other questions? Thank you.
Hey, David, my mic has run out of juice, I think. If you have other, can you turn this off? Yeah, if you have other questions, Dave will be around a little bit after worship this morning, and if you have complicated legal questions, call and make an appointment at his office and visit with him. He has volunteered his time to be with us today and last Sunday, and we appreciate that very much. And there are still a lot of questions that we have that I've got, that I have run into throughout my counseling practice that perhaps some of you haven't thought about. But these have been helpful to us, and I think that we need to be thinking seriously about that. We continue our class next Sunday on aging gracefully, and we'll move into February. We'll finish up death and dying in January, and then in February we're going to talk about fear and failure. So kind of a wrap up of everything, so that we can make sure that we're trying to do the best we can with what we have. I think that's obligatory on us as Christian people to make good decisions. So thank you for being here, and thank you, David, and his family for being here with us today. We're dismissed.